Hello, everyone. I'm Kevin Gosztola, and welcome to this broadcast. It's been a little while since I've been live on the channel, but we have some important breaking news to cover. So I'll just, I'll get to it here. I'll bring Chip back into it. Chip Gibbons, Policy Director for Defending Rights and Dissent, is my guest today. But I'll just do some shameless plugs here before we get going and encourage you to go to the dissenter.org. Where the URL is at the bottom, go to the dissenter.org and subscribe. If you are not subscribed already, to get this news, get independent journalism on whistleblowers and government secrecy and press freedom. There's work going up every week, if not every other day. We try to keep things covered as much as possible. And Chip did a report for the Dissenter on this case that we're going to be discussing, was at the hearing in Alexandria, Virginia, in the Eastern District of Virginia. It involves CIA employee Asif Rahman. And so we've got some developments to get to. Rather than me set it up, Chip, welcome. Why don't you tell people what the hearing was about and where things stand? He's accused of violating the Espionage Act when he allegedly leaked documents related to Israel's plans to launch a military strike against Iran. Take us from there.
Yeah. So in October, two documents originating with the National Geospatial Agency.
Chip,
I know
your screen is frozen. So,
am I audible or just am I frozen?
I can hear you, but we have a frozen video, which is okay.
Am I back?
There we go. We see.
Hello.
We see you.
I feel seen.
You're catching up. Okay. So Go ahead. Tell us what you reported on today.
A Telegram channel called Middle East Spectator posted two documents originating with the NGA, National Geospatial Agency. Some media erroneously reported one of them from the NSA. They were both from the NGA that were about Israeli military capabilities and Israeli strikes on Iran. I believe the documents were posted on October the 18th. Is that the correct date, Kevin? And we now know that the documents were go away again. We now know
your connection is catching up here just a little bit. But yeah, the date it was around October 18th that they appeared.
And we now know the documents were created just 48 hours before they were transmitted online. This came up at the hearing. After that, in November, the FBI arrested a CIA agent or CIA officer, Asif Rahman, who, based on the indictment and the evidence given in court, they clearly believe is the individual who released those documents. A couple interesting notes. Middle East Spectator has claimed online they did not have direct contact with the source, that the documents were originally posted in a separate Telegram channel of 7,000 people. Would that be helpful if I fixed my Wi-Fi or... No. Okay.
Let's see. You broke up a little bit there.
Okay. Can you give me a minute? I'm gonna log back in.
Yeah, that's fine. Everyone, thanks for working with us on the technical difficulties. I'll do a little bit of talking here for Chip about some of the issues that as they stand. So this is a Espionage Act prosecution in the Eastern District of Virginia. It's the same division, the same court that was going to be litigating if Julian Assange had been extradited. If WikiLeaks founder Julian Assange was extradited, he would have gone through this court under the Espionage Act. He would have faced charges. And the same judges in this courthouse are judges that typically hear national security cases. They're very deferential to the national security state and the wants of the U.S. prosecutors who come there and are hugely protective of intelligence and military agencies. So when they make claims and they are unfounded, in a number of instances, those are taken at face value by a judge. And so Chip was at these proceedings today. I understand there were several reporters that tuned in because this has gotten quite a bit of attention. The leak back in October was one of the more high-profile instances of leaks under President Joe Biden, but also came at a time when people felt like we were on the brink of a very broad regional conflict in the Middle East, and that this would contribute, that this the exchange of missiles between Iran and the Israeli governments was something in which we were going to continue to see further destruction. So let me bring Chip back in. Chip, I was just laying out some context more broadly about what was happening around the leak at the time in October, and what made it such that you were at court today and there were, you said, several reporters that were engaged in and following what was happening at this hearing. And that's because this is one of the more high profile leaks that have occurred under President Joe Biden. This is a case also where when these documents appeared on Middle East Spectator, a lot of people were feeling like, well, we're super close to World War III. Like a lot of people felt like there was going to be a lot that happened.
It's funny you should mention World War III because that came up in the prosecution's arguments to detain Mr. Rahman. I believe this is the first time I've ever heard preventing World War III cited as a reason someone was a danger to the community, but obviously I don't work at the Department of Justice. So obviously this person was arrested. We know through the court filings that there's only one set of documents and one revelation that's being referred to. I mean, in the motion to justify detaining him, they literally gave a verbatim quote from the Twitter account that posted the documents with like the name of Israel and Iran redacted. But if you search Twitter for the rest of those words, the tweet pops up. That's how I found it. The time is the same. So there's zero question that this is a case about an individual who stands accused of taking two NGA documents about Israel's preparation for war with Iran, preparation for military strikes on Iran, and somehow these documents found their way online. The government has not, in any of the briefings I've seen, and I have not yet seen the motions for today because they were filed very late, has not made the connection yet. And Middle East Spectator has made the sort of claim that they don't know who the person is, and they these documents were in another Telegram channel that had 7,000 people in it, and that somebody DM'd them about it, who also DM'd other journalists. So on Friday of last week, the Department of Justice appeared in court to argue that Rahman should be held in pretrial detention. And what's important to note here is that Reality winner Chelsea Manning, Jack Teixeira, and Joshua Schulte were all held in pretrial detention. But the Espionage Act is not one of the offenses that carries with it a presumption that the defendant should be held in pretrial detention. And as far as I'm aware, this became a point of controversy today. No other defendant has ever been held in pretrial detention in the Eastern District of Virginia who was charged under the Espionage Act. The government tried to argue there's someone who's currently being held under a lesser charge about classified information. I was not familiar with the case, and that somehow meant this wasn't an anomaly. But this is pretty much an unprecedented move within the Eastern District of Virginia, where most of these cases are brought. So while we've seen elsewhere the Schulte case, the Winner case, the Teixeira case, and Manning is a real outliner because she was in a military court-martial, people being held in pretrial detention in this district where these cases are routinely brought, in part because the judges are so sympathetic and deferential to the government. No one has ever been held like this before. And the judge on Friday was a magistrate judge, and he was very aggressive and hostile to the government, and he denied their motion. He denied their motion to keep him detained, as well as their motion to stay his order. Within a few hours, the district judge, Judge Giles, she issued a order to stay the release of Mr. Rahman pending appeal, and she today in the appeal process ruled in favor of the government, ruling that Asif Rahman is both a danger to the community as well as a flight risk. The government presented a number of arguments today that were much more polished than they were on Friday, but they were also still really some of the weakest arguments I've ever heard. In terms of him being a flight risk, they argued because he has a familiarity with foreign travel, and because he applied to law school in Canada 4 years ago and didn't go, even though he got in, he's a flight risk. The defense pushed back on this, noting that all of his foreign travel was in connection with his job with the CIA. But the judge was like, sure, it was in connection with his job in the CIA, but it means he's familiar with foreign travel, which is a really sort of remarkable slap in the face to all of the people who work for the U.S. government and travel for their job, because that now means, you should be detained because having familiarity with foreign travel makes you a flight risk. It also really doesn't hold up, because the conditions he would have been subject to would have required both surrendering his passport as well as, being on an ankle monitor. So it's not like you could just get on a plane and go to law school in Canada. The other arguments they made about why he was a danger, a lot of them were about these are top secret documents. And that because they're top secret, even though the Espionage Act is not a presumptive offense that carries a presumption of pretrial detention, it makes the danger to the community so great. And the judge, to my dismay, bought that argument. And I do not believe he is the first person accused of leaking top secret documents. The other thing they kept stressing was that this was a document about an ally's military actions against an adversary. The document was transmitted 48 hours after it was created, and that they're very good about usually not hello, I guess my research assistant has appeared. They're usually very good about not mentioning the name of that ally, but Israel was mentioned twice by name today, once in relationships to statements made by U.S. and Israeli officials that the documents did no harm, which the defense submitted as evidence that there was no harm, to which the Department of Justice basically said we can't expect the government to tell the truth in its public statements, because that would be tipping an adversary off, and also implied that the spokesperson for the National Security Council was less knowledgeable than they were. And so we have that. And then we have this second reference to Israel where they're making the case that he's a danger to the community because the situation in the Middle East is so volatile, and that they cite it, and that an example of the volatility was the events in Syria, and that Israel would have to react, or was reacting to the events in Syria. And it's not clear if this was a general example of volatility in the Middle East, or if this was in relationship to the fact that the previous disclosure was about Israel's plans to attack Iran. They implied this person was ideologically motivated. I'll get to that in a second. So therefore, they might release information about attacks on Syria. The implication here then is that the U.S. government considers any sort of disruption to Israeli war making, even when that war making is in clear violation of international law, as is Israel's colonization and carving out of Syria at the moment, that is a threat to national security and thus a threat to the community. The standard is the person will be a threat to other individuals, safety of other individuals, or the community. It was very clear for purposes of this hearing that national security threats was considered the same as threats to the community, and apparently Israeli war making is considered the same as U.S. national security. So that's very disturbing. Another argument that was made was that this individual must be motivated by ideology or have an emotional motive, which makes him more dangerous. The judge asked if they had any affirmative evidence of this. The bulk of the case was that this individual is quite wealthy. His father ran a private equity company. Apparently, he has access to a family trust. He has a very fancy lawyer, and that because he is so wealthy, he couldn't have been bribed. I'm not, persuaded by that argument in the abstract, but let's take it as true for today. He could have been bribed, therefore he must have acted ideologically. They also said the close proximity to when the documents were created and when they were released suggested an ideological motive. The judge did not buy that. And then they also stated that the source of who published them showed an ideological motive, as well as people's responses on social media to the publication. And one of the things that was mentioned was that either the Middle East Spectator account or someone tweeting or Telegram, is that the adverb for Telegram? I've never used Telegram. Perhaps I should be on there since we keep getting important information about Israeli war making. Hello, Marcus. That because of this, that it must be ideological. And one of the things they explicitly mentioned was that one of the people online, and I'm not sure if it was Middle East Spectator or a random user, described this as preventing World War III. This is the first time I've ever heard the prevention of World War III being cited as making someone a danger to the community. I generally think of preventing World War III promoting the safety of the community, but obviously I am not in the U.S. Department of Justice. And the judge rejected any sort of third-party social media comments. The other information they had, again, was that he deleted 1.5 gigabytes of data. They claimed he should not have had access to any information about the Middle East because he was read out of Middle East intelligence in October 2020, and they believe he continued to maintain documents about the Middle East that he deleted. The defense disputed that's what was deleted from his computer. The judge accepted this as obstruction of justice and therefore evidence of a guilty conscience. The other issue that came up was when they searched his house, and this is very strange to me, they found a handwritten list of encryption or rooting applications. Rooting is something that you do with a mobile phone that secures it. The judge didn't totally accept that, and the defense pushed back that rooting and encryption was very common to anybody who, quote unquote, knew how mobile phones worked, and that most people in intelligence root their phones or use rooting on their phones. And then they also claimed that he had knowledge of covert identities. He's not accused of releasing covert identities, but he has knowledge of covert identities, and that would be very dangerous if he would release them. And that also his knowledge in his mind of covert entities and other secrets not only makes him a danger to the community, it makes him a flight risk, because that's information that another country, especially a Middle Eastern country, would want to receive. And I guess they would offer him asylum in exchange for exposing covert actors. Again, this is ridiculous because this would essentially apply to anyone in intelligence. And there are no allegations he released covert entities. And the government was very clear earlier. He was not motivated by money. He's not being accused of giving information to a foreign government. So this is a complete speculative threat. And the standard here is clear and convincing evidence, which is supposed to be a very legally high standard of danger, or preponderance of the evidence, more likely than not, of a flight risk. And it just does not, none of this follows. They were again on this pocket litter. I've never in my life heard the phrase pocket litter before last week, and now I cannot get rid of it. So they found an 8-page handwritten series of to-do lists with dates. One of the to-do lists had on it, run. He's a runner. He runs 15 miles a week. Contingencies. No contingencies were listed, just the contingencies. And vacation, November, ? And he had purchased round trip tickets for a vacation, which the defense noted that since they were round trip, he was intending to return. And then the rest of the to-do list is, I guess, written in strings of alphanumeric codes. And it would appear to be, or just strings of letters, some of which are capitalized, some of which have punctuation, which would indicate he's made, in the government's mind, some sort of handwritten like cipher, like the Zodiac did, I guess. It's very bizarre, and that they're convinced this contains either classified information, since one sentence that was not in the cipher language referenced a type of missile the U.S. has, as well as I don't know. It's very difficult to follow this part, the pocket litter argument, and the judge just bought the idea that based on the characteristics and nature of the offense, since it involved top secret information, since it involved a volatile region, since it involved kinetic military action, and since the defendant is wealthy, has experience with international travel, and he had this encryption, there's a flight risk as well as a danger to the community. The lawyer afterwards said they're going to appeal this, so we'll see what happens. I do have to say this was an incredibly weak presentation from the government, and I am stunned. And I am stunned that the judge found the government met the more likely than not burden for flight. The flight stuff is really weak. Nonetheless, the clear and convincing, which is supposed to be the second highest legal standard after beyond a reasonable doubt, that he's a danger to the community, danger to national security. And again, with the flight risk, it isn't just the person might try to flee or has some potential for flight. It's that it's more likely than not that no amount of conditions imposed on the person could guarantee their appearance in court. And the conditions include taking his passport, putting an ankle monitor on him. The idea that those conditions cannot guarantee this person's in court is just preposterous. And then there's the issue of the other danger issue, is that the family had agreed to pretrial conditions that pretrial services came up with to limit his access to electronics. They wrote up a whole plan and signed it, and it was given to the judge. And the judge basically said they don't make decisions based on families, and they would not entrust any family with ensuring either community safety or national security. Again, it was community safety or national security. And that it doesn't matter because you can't stop him from talking. And here, even talking is a danger.
All right. So thank you for that presentation. And there are a few things that we should probably go into a little bit more. But first, someone asks, and I'm a little bit baffled, who is this? And I just want to say this is Chip Gibbons, the policy director for Defending Rights and Dissent, as it says on the screen. And you should go to the dissenter.org and read Chip's report, which he did on the arguments around pretrial detention, which took place in front of a magistrate judge last week. And that this is a person who is an expert on these Espionage Act prosecutions, works on Espionage Act reform when it comes to those conversations and pushing that kind of legislation.
Frequent guest on your stream, you know.
Been here before, and also it's just a little bit weird to say who is this when it says it on the screen, and everybody has access to Google and can go look up a person and figure out where they come from and who they are. So sorry, I couldn't leave that alone.
Maybe it's an existential, like who am I?
Yes. Well, the person is also a cat lady, and I should tell them that you're a cat person as well. You are somebody who will frequently, we will frequently say, oh, well, I had no idea that that's what they were asking. They're asking who is the leaker. Okay.
Asif Rahman. Yes. Asif Rahman is an employee of the Central Intelligence Committee. His father is a Bethesda-based private equity manager. Asif Rahman was the valedictorian of his high school. He went to Yale. He then entered into the business. In 2015, per the defense, he left the business community in order to serve his country by joining the CIA. At some point in his CIA career, he was responsible for some type of Middle East intelligence. In October of 2020, he was read out of the Middle East program. It's not clear to me why. He also, at this point, contemplated going to law school in Canada. Someone who has contemplated going to Montreal to study French. I didn't know this made me a danger to the community. And then he was stationed at the embassy in Cambodia, where he had the responsibility, I forgot to mention this, Kevin, where he had the responsibility for printing classified documents and putting them in a book for the other embassy staff. Clearly, it's an embassy that's a cover for CIA activities in Cambodia. And that one of the documents he printed, because the government claims only one person in the entire U.S. government printed the documents in the format they were published, which I don't totally know what that means, but let's go with it.
Okay.
That only one person in the entire U.S. government printed the two documents in the format they were published. I don't know if they mean PDF, if they mean like the headers, and that the defense responded to that by pointing out that it was his job to print information that was put in a book that was distributed to embassy employees, and that the documents were also available to members of the Five Eyes nations, meaning someone outside the U.S. could have printed them, and that they also, the prosecution then responded with, and this is an interesting response, that looking at the table of contents for that book, I don't know where the book is, if they burn it or something, only one of the two documents appears to have been featured in it. Therefore, he would not have had need to print the second document that was from the same time period on the same topic that he did have need to print. I find that argument from the prosecution to be ridiculously weak. But, you know, I was kicked off a jury recently for my anti-federal government bias, Kevin. So
your anti-federal government bias. Okay.
Yes, it was a J6 trial too.
Oh no.
Yes. I arrived in court for jury duty, Kevin, and they said, this case is about a defendant who's being charged with picketing without a permit. And I'm like, oh, what a bullshit charge. And the judge continues, in connection with the events of January the 6th. And I'm like, wow, how did I get called for this? But then when I mentioned I wrote a lot about Julian Assange's case, the defendant, their eyes like lit up. But the prosecution was very concerned I was biased against the Federal Bureau of Investigation. You can believe that, Kevin.
Not you. Biased. Okay. All right. Well, let me just say, I'm sorry I was I made so much out of your question, and thank you for clarifying, Cat Lady. So it was a fair question. We've gone on, and the identity of the person we were talking about got a little bit buried in the conversation. So thank you for saying all of that, Chip. That way everybody's clear on who Asif Rahman is. And it's important, although we don't want to do character assassination, we don't want the message to be overshadowed, but let's just keep in mind who he is. And I do want to say that Reality Winner's case, in my head, when I listen to you speak about how he's being punished for the skills he's been taught or the travel that he did as a CIA employee, I remember that in Reality Winner's Espionage Act case, that she was kept in jail because she could translate, because she could speak Pashto, Dari, Farsi, because she had some knowledge of the Taliban, that she was able to, that I remember also she was interested, spoke about how she would like to go to Syria and help refugees. If she could do some humanitarian aid and maybe work with one of those like Doctors Without Borders type organizations. And that was turned against her as if like that would be some cover for aiding terrorism. So this is the trend. The government employees that are trained either in the military or at these national security agencies, they're then seen as like when they show a dissenting viewpoint, when they exhibit manner, when they act in a manner that goes against what the U.S. government wants, then everything that they've learned, that becomes, okay, we think you could be an operative that is turned against the U.S. government.
Yeah, and again, with Mr. Rahman's case, we have no evidence of any political commentary whatsoever. The government has argued he must be ideologically motivated, and I was waiting for like, you know, he went to pro-Palestine protest or he tweeted derisively about Netanyahu, and it was none of that. It was just, he's so wealthy, what else could it be? Also, the Middle East Spectator is a political source, and that somebody tweeted about stopping World War III who was not him. I mean, that's such a weak argument. And, you know, on top of that, if the argument is you are dangerous because you're motivated by something other than bribery and corruption, that applies to every whistleblower, every journalist source, every conscientious person. And the idea that someone who is conscientious and working with the media is a greater danger than an actual spy who sells out their country for money. I mean, think about what the government's really saying here. I mean, if you actually like follow the government's arguments to the logical ends, it's anybody who ever travels ever is a flight risk. If you travel for the government as part of your job, we will punish you by holding you in pretrial detention. Israel's war making in violation of international law is the same as U.S. national security, and U.S. national security is the same as a threat to the community. And, you know, if you act out of good motives as opposed to treasonous ones, you're the more dangerous person. It's stunning. It's a stunning presentation. I doubt the prosecutor has ever thought through the implications of anything he's saying. I don't think he's sitting there with this sort of sinister. He's something sinister, but not this level of sinisterness. But it's just such a depressing argument. The other really interesting thing, Kevin, is that at the start of the hearing, and I should mention, in addition to the appeal, there was an arraignment, and Rahman has officially pleaded not guilty now. He's pled not guilty. The judge said, given the nature of this charge, it's going to be a complex case, so I assume the defense is going to waive their speedy trial rights. And the defense attorney got up and said, at this point, we've not waived the speedy trial rights. So the trial is scheduled to start in February.
All right.
I believe they will waive their speedy trial rights, but I'm intrigued by the fact that the judge just started off with, I assume you'll waive these rights.
Yeah. Okay. Because otherwise, you can be in a situation where you get to February and then the prosecutors give you all this discovery and you just have like 10 days before the trial to get through all these boxes. Okay. Now, can you tell people about who the attorney is that's representing Asif Rahman? You went into detail about this person in your report, and I think people should know about Asif Rahman's lawyer who's representing him.
Very interesting. At his initial appearance in Guam, he was represented by two public defenders. Since then, he is being represented by Amy Jeffress of Arnold & Porter. Arnold & Porter is what's called a white shoe law firm. It's a very prestigious law firm. It's the type of place they would not let me in the door, Kevin, to be quite blunt. But it's a really high-powered and connected law firm. She's the head or co-chair of their white-collar criminal defense practice. She also specializes in national security law. And here is where it gets interesting. Before being in private practice as a defense lawyer, she was a prosecutor. She was the head at the D.C. U.S. Attorney's Office of their National Security Section. After that, she was Eric Holder's counselor for national security and international matters. And after that, she was the U.S. legal attaché at the London Embassy, where she cooperated with the Crown Prosecution Service on extradition. So quite literally, she has been a national security prosecutor, and then she was like an advisor to Eric Holder. Since going into private practice, she's had another important, interesting role in that she was one of the public advocates for the Foreign Intelligence Surveillance Court following Edward Snowden's disclosures of the illegal, unconstitutional NSA surveillance against Americans. One of the reforms, and wasn't much of a reform, was better than nothing, was that they had to appoint a public advocate for the Foreign Intelligence Surveillance Court. We call it the FISC, that will sort of argue for civil liberties perspectives or the public. And in one of the amicus briefs she filed before the court, she argued that the FBI's warrantless searches of NSA collected foreign intelligence surveillance, this is under the 702 powers, constituted a Fourth Amendment violation. So she is someone who has access to classified information. She is someone who was a national security prosecutor, and she is someone who's well connected enough that she was appointed as a public advocate. And in that role, she actually advocated for the public. So she's a very fascinating lawyer. She also is the type of lawyer you get when you have access to a multi-million-dollar trust fund and your family is putting up their $2.1 million house in Bethesda as collateral.
Yeah. Okay.
So most Espionage Act defendants do not have an attorney like this.
No, you would not typically see connected people. Daniel Hale had a public defender, right?
Yes. And then Julian Assange and Jeffrey Sterling both had Barry Pollock, who I don't want to cast shade on. He did represent Ken Lay, the Enron guy, and get him off. Although that, so yeah, I mean, Barry Pollock was a pretty powerful attorney, and I believe John Kiriakou had some good lawyers too.
He had a very famous lawyer, Plato Kacharis.
Yes,
but then
Joshua Schulte, Daniel Hale, Tom Drake, all had public defenders. Did Reality Winner have a public defender, or?
No, but I'm not sure how much she would have had to pay. She was represented by people based in Augusta, Georgia, and they typically wouldn't handle this kind of national security case. So these were lawyers that were coming in and educating themselves on the Espionage Act for like the first time in their lives that they'd have to like represent and litigate the case for somebody. So, she didn't go out of the region and bring in somebody from DC to represent her.
And I will say the federal public defenders are quite good attorneys. I know there's a lot of stigma of being a public defender, but it is really hard to get a job as a federal public defender. It is a very sought after position. They have very high profile cases, the Boston bomber, things like that. And they are an exceptional group of attorneys. So I would not say that Daniel Hale did not have, good legal representation or things like that. But it is interesting that instead of a federal public defender, we are seeing a white shoe law firm with somebody who used to work directly under Holder for national security matters. I do not know what her billable hours rate is. I imagine I would not be paying my mortgage ever again if I got like 2 hours of her service. Maybe not 2 hours, but you know.
Okay, so let me throw another question at you just because it's topical.
I love questions.
And related to this leak prosecution. There is a piece of legislation that is before the Senate right now that passed in the House. It's called the Press Act, and it is a reporter's shield law. And now I would like to ask you, because I have been told by Senator Tom Cotton's office that people like Asif Rahman would directly benefit if we expanded protections for reporters. So could you tell me, and maybe you can detect the way that I'm asking this question, but maybe you could tell me, how would Asif Rahman have benefited if there was a reporter's shield law on the books?
If we assume the representations of the federal government in court are accurate, can I give that caveat?
Yeah, with that caveat. If he is the leaker.
But not just if he is the leaker, if the government is honest about how they deduced him as the leaker, because a lot of times it was called parallel construction, where they get information through nefarious means and then they make up some other story. But assuming that's not going on here, and I'm not saying that is, I just know there is, well, I won't go there. I just know there's another whistleblower case where there is some concerns privately that the journalist was in fact spied on. So in this case, there is nothing in the documents, in the indictment, in the motions for detention that suggest there is anything the Press Act would have done to protect him. The Press Act prevents the journalist from being forced to give up the source or surveilled to give up to identify the source. As far as we know, there is no real journalist here. I mean, Middle East Spectator, you can debate whether or not you think they're journalist or not. I think that's a very complex topic at this point, but there's no inference that they were surveilled or spied on, and they don't claim they even know where the documents came from. Instead, what the government claims is that they were able to identify the documents which were printed and photographed. And that's quite interesting because after the Reality Winner leak story, the government was able to sort of, I guess, identify information from the document itself. So we've seen people photograph them documents in order to not get that information out. But what they're saying is that the documents were within less than 24 hours, the US government, an unnamed agency, I would assume NGA, NSA, or CIA, that really narrows it down, I know, likely accessed through a particular US government computer application, US government application number 1, hosted on the servers in Eastern Virginia. The application allows classified documents to be turned into PDFs. By accessing the document, a unique PDF is created, the user is logged, and the PDF is assigned a unique URL. So what I understand is that for this agency, in order to read a document that is classified, you go through this program that creates a brand new, unique PDF, and that PDF logs that your log is the one who accessed it, and that PDF contains a URL. Based on the photographs of the documents, the government determined only one person had accessed and printed those 2 documents. So the Press Act would not have prevented the detention of this individual. There is we can argue about whether or not there was a journalist, but there is no evidence or allegation that Rahman directly gave it to Middle East Spectator, at least not yet. There was no surveillance that's been noted of Middle East Spectator sources. And the way in which he was ferreted out was based off of looking at the documents and determining who had printed them, which would not be prohibited from the Press Act. And the Press Act is a protection of the reporter. It's not a protection of the source, right? There's no law that would prevent you from getting an accused source's communications, to my knowledge.
Right, because as legal scholars argue about the state of Espionage Act law, there is it is grossly skewed in the favor of protecting government secrecy. Like the lay of the land grossly protects the government's interest in secrecy, while meanwhile there's been a kind of detente, at least up until Julian Assange was prosecuted, where once you had the documents as a reporter, you were pretty much in the clear unless you were going to publish something that helped a group launch a nuclear weapons attack against Capitol Hill or the White House or something like that.
There isn't a ton, but there was the attacks on Ryzen under Obama to try to make him reveal his source. And we do know that under the Trump administration, the DOJ tried to access communications records for CNN, New York Times. Who's the third one? I'm blanking. I don't know. And
Washington Post?
I think it was Washington Post. And that is what caused Garland to put in the Garland guidelines. Initially, Garland continued on the Trump attacks on the New York Times and put a gag order on the Times and even talking about them. Fun Garland fact. But then he reversed course, put these guidelines in place. The Heritage Foundation, which I know Rachel Maddow and MSNBC talk a lot about, but let me tell you, back in the 70s and 80s, it was Covert Action Bulletin, Counterspy, The Nation, and people like us who were talking about them, very deeply connected to the deep state, probably helped Ronald Reagan draft Executive Order 10333, a push for a war on terror starting in 1990, very bad people. They are pushing for those guidelines to be both rescinded and for the FBI to hire more counterintelligence agents explicitly to engage in surveillance of journalists, identify their sources, and prosecute them. And the Heritage Foundation has the very interesting position on the Espionage Act that they want the Espionage Act to be reformed because it was so broad and unconstitutional, it could have hindered a prosecution of Julian Assange. Not that the Espionage Act is so broad and unconstitutional that it could allow for an otherwise unconstitutional prosecution of Julian Assange, but because it was so broad and unconstitutional, Julian Assange could defeat his just prosecution on a technicality, which is the most interesting Espionage Act reform argument I've ever encountered, Kevin.
All right. So Tom Cotton is full of shit, and he's standing in this. He was standing in the Senate yesterday to give a speech and basically lie about what a reporter's shield law would do. As he did 2 years ago, he said much the same thing about how the floodgates would be open for leaks. And the fact of the matter is that you can protect the national security interests of the United States and also protect reporters. And also, according to Wyden, they actually gave in to some of this hawkishness or national security state complaints that they were receiving from the Justice Department. Apparently, there are now exceptions in the legislation, or there's an amendment that was put forward that would involve anything related to Section 702 surveillance, which, by the way, is actually something that we should know about, because we've seen countless abuses when it comes to people's privacy rights, and that's spanned both sides of the spectrum. There have been January 6th people who have been targeted inappropriately, and there were Black Lives Matter protesters that were targeted inappropriately. You look like you were going to say something.
And it's a complete repeat of abusive NSA surveillance in the 60s and 70s. I'm blanking on the name of the NSA program. I don't think it was Shamrock. I think Shamrock was the telegrams. But there was a program in the 60s and 70s where the FBI and the military, most of the FBI, would have the NSA search for communications data about a lot of Black Panthers, unsurprisingly, to try to tie them to foreign influence or foreign interference. And we know the J6 people and the Black Lives Matter people, pretty much that was the same situation, that they were looking for foreign influence. And when you consider that in the 60s and 70s was for Black extremists, and now it's Black Lives Matter, Black extremist, FBI's term, not mine. Please do not attribute that language to me. It's pretty much a repeat of the same program. And this was considered one of the most abusive programs the Church Committee uncovered. It prompted all kinds of new protections and guidelines, and pretty much everyone but you and I just sort of, shrugged their shoulders this time around.
Right. Okay. Well, I just want to talk about that dimension. There's a lot to get in with the Reporter's Shield Law for another conversation, but I'm going to start winding this down. So as we look ahead, you said the trial is currently scheduled for February, but that will most likely move. There's no way that date's going to stay.
One of the, I don't know.
Well, in your educated opinion and mine, I would just say that typically with these cases, things get like Chelsea Manning's case, things were constantly being moved to other dates because of how much paperwork and all sorts of documents and all kinds of even if he's going to get his money's worth from Jeffress, she's going to put in the pretrial motions to challenge the Espionage Act. And you got to go through the motions and say, this is unconstitutional because it's vague. This is unconstitutional because selective prosecution. I mean, you got to go through those. So, and you're going to put forward things before the judge that'll probably be meaningless to them, but you still have to put that information before them about, hey, Joe Biden was found with documents in his garage and he didn't get in trouble. And also the special counsel's investigation into him actually confirms some things that, suggest that anybody who wasn't the president would be prosecuted. So it's just kind of I And then, of course, you have the Trump instance of him having documents. And I know that those weren't disclosed to the press, but you still have to go through the motions of challenging the Espionage Act. And by the time you do that, how does it not push the trial date?
But that's the burden on the government at that point. If you don't waive the right, that's my understanding. My understanding is that when people think the government's case is particularly weak, they will not waive it. But this is not an Espionage Act case. This is in another trial I was aware of. I won't say which one. It was not a national security trial where there was something like 100 defendants. And some of them, the government had more solid cases against, and other ones it had weak cases against. And the defendants who had weak cases refused to waive their speedy trial rights. So like the first 7 trials the government brought just resulted in the case collapsing. But that's a very different situation. I don't know. A lot of calculations go into this. I think the judge was surprised that Jeffries was not waiving the right at this time. It's possible she's going to try to call the government's bluff. I will note that at the Friday hearing, there was some kind of reference to government agencies not getting them information in time and wanting more time to get information from those agencies. So if the government is slow walking, like CIA, NGA, NSA are slow walking, turning over stuff to DOJ, and they don't always want this kind of information given to the DOJ, there could be a legal trick here for not for asserting the speedy trial right and messing with the government. 9 times out of 10, it's what you're describing, Kevin, and I suspect you're correct. But I'm just
okay. So just as we wrap here, to me, the big takeaway from the development right now is that the Justice Department, and this will exist under Trump, as people are leaking information about his administration, about what agencies are doing, and we both share the same view that there will probably be increased corruption. I'm not saying that these agencies don't have corruption that are a part of what they do. Hell, I've seen so much about how compromised the EPA is by plastics manufacturers, chemical producers, etc. But it'll be much worse under Trump. And so now they have a precedent in the court that is known as the Espionage Court for jailing somebody who is prosecuted under the Espionage Act, keeping them in pretrial detention. So not only do you have, if you're going to leak, to worry about going through a trial, worry about being brought up on criminal charges, you have to worry that once you are charged, you would go to the Alexandria Detention Center and be jailed. And mind you, when we followed Julian Assange's case, we heard about how there's administrative segregation or solitary confinement in those facilities. So they can put Asif Rahman, I don't know where he's being held, but they can put someone like Asif Rahman in a cell, a wing of the detention facility with a very, very thick steel doors, to where, like, if he wants to communicate to anybody nearby, he would have to shout at the top of his lungs. It's almost impossible to have a conversation. He might actually not be allowed out and be fed all of his meals through a door that, like, they just put it through a flap in the steel door.
Yeah, no, that is, and I think it's worth pointing out that one of the impacts of that type of pretrial detention, and I wrote about for Jacobin specifically conditions at Alexandria Detention Center, interviewing people who had been held there, including Jeffrey Sterling, a whistleblower who's a Defending Rights and Dissent board member. One of the impacts of that is it does encourage the person to plea. I believe one of the reasons why Reality Winner pled out was because conditions at the detention center she was at were so terrible. Obviously, the government can't state that's why they're doing it, but I would suspect that is heavy part of the reason why they want to put Rahman in pretrial detention and then protract the case out so he doesn't take it to trial and continue to be subjected to these horrible conditions.
Okay. All right, so we have the trial coming up next year. We'll stay in touch and we'll cover any developments. There probably won't be anything that major now.
The defense is appealing this decision.
Okay, there could be news on the appeal before the end of the year, but barring any developments, it won't be until next year that we cover this case. we're in a transition. We're going to see continuity in the sense that these leak cases have happened. Obama prosecuted more leakers than all previous presidents combined. That was something that Pentagon Papers whistleblower Daniel Ellsberg was very quick to remind people of constantly as he spoke up for people like John Kiriakou, Chelsea Manning, Edward Snowden, etc. But it's going to get worse, and there's also going to probably be an effort to go after reporters. So this is going to be a case that the Trump administration inherits, and they're going to aggressively want to go after these, because in fact, we're hearing conservative legal scholars or former Bush administration officials or former Trump administration officials talk about how reporters shouldn't only be forced to expose information that is potentially harmful to the national security of the United States, like they should be dragged into court and be forced to give up their sources, but also if they have information that could help the Israeli government or help allies of the United States, that they might potentially also need to be dragged in court and forced to testify about those sources. Like if they know about where supposed terrorist group is going to attack, let's say, an Israeli military base, or if they talk to somebody who gave them information, then so like, you know, who's to say that any of the people who the press might interview in Syria that are taking over the country, you know, if they interview them, and they certainly have ties to jihadist groups, well, if those people become persons of interest to the Trump administration, they might try to haul in the reporters who worked on those stories and find out their sources. This is where we are headed.
You also see an independent media outlet right now, Palestine Chronicle, coming under attack, both in a slap suit and with an effort by members of Congress to have their 501c3 status taken away, where you are seeing this claim. So one of their contributors allegedly or turned out to be a Hamas member who kept hostages. There's no evidence that knew anything about this, but people are arguing that because they used language like ethnic cleansing or resistance, that they were aiding and abetting terrorism or publishing Hamas propaganda. And that you are going to see a trend, I think, with the attacks on pro-Palestinian media. And sort of all of the different media attack trends under the Trump administration could converge into something quite horrifying.
And we have the IRS and the person who's going to take over the IRS being open about exercising this authority that will go, like, probably be really difficult to challenge, of removing people's tax, their nonprofit status, their tax exempt status as a nonprofit organization, which is going to affect the way that Palestine Chronicle and some of these other outlets are able to raise money in order to do the journalism that they do on a regular basis. So anyways, we need to wind this thing down. And why don't you tell people where they can go to support your work, Chip, because this is important. Tell them Defending Rights and Dissent, where they could go to support Defending Rights and Dissent, and then to follow what you do.
Sure. Defending Rights and Dissent is a national civil liberties organization that defends the American people's right to know and freedom to act through advocacy, journalism, policy expertise, and grassroots mobilizations. You can find us online at rightsanddissent.org. We have been posting to our document cloud the various trial documents. I just found out I'm in arrears on my Pacer fees, so I can't log into Pacer. But I will pay my debt to the government, and we will be linking to that on our website, Defending Rights and Dissent, so people want to see the trial documents themselves. Defending Rights and Dissent is also online at Twitter at Rights Dissent. I'm at Twitter at Chip Gibbons 89. I also, like everyone else, has migrated to Blue Sky, and I have no capability of remembering my Blue Sky handle. It is chipgibbons.bsky.social. You can find me there.
All right. Well, I think we've had a fair amount of people watching through X today, which I don't want to use that, but it's Twitter. People have been watching us over there, so I thank you for tuning in. And also, I assume a few people got through the Google algorithm and found our YouTube stream. So thank you over there for watching. I might be back. It's possible that there might be a conversation here with John Kiriakou that was planned to catch up and talk with him. He was invited to join this conversation, but scheduling got a little bit wonky. But Chip, it was really good to talk with you. Thank you for your reporting. Thanks for contributing your reporting to the Dissenter so that we could share it with everyone. And everybody, you have a good rest of your day, and we'll see you again soon.
Bye, everyone.